Good morning, Your Honor.
Good morning.
Or I guess we're actually into the afternoon now. I apologize.
Yes, good afternoon.
Oh, and just so the court knows, there's actually a depot going on, and I just stepped out. I'm going to have the hearing and then step back into the depot, so I'm not in office. I brought a jump drive with extra stuff just in case theory on it. And
Okay,
hearing notebook, so I think I should be fully prepared.
all right. Well, that's one of the beauties about being virtual. You can be in more than one place at once. So we just wait. I think we are expecting quite a few other people on.
I see they're listed. I just don't see that they've joined us yet.
I see Joe Cleveland, A. McCall, myself, and the court reporter.
Yes, ma'am.
Good afternoon, Your Honor. Joe Cleveland.
Good afternoon, Mr. Cleveland.
How are you doing?
Doing great.
Good. I'm going to call for Ms. Perez. Hang on one second.
Okay. Good afternoon, Mrs. McCall.
Good afternoon. How are you?
Doing well.
Okay, I'll have Angelique send it to you. We're on right now. Okay. Ms. Perez was having difficulty getting on. Angelique, would you mind sending her the call-in, the Zoom link again?
Sure.
And Joe, as long as you're on, Your Honor, just as a procedural matter, unless Joe objects, I think probably a proper order for the hearings would be the motion to enlarge, then the motion for new trial, and then the motion to sever, unless Joe's got a problem with that.
I don't have a problem with that.
At least to me, it seems logical.
Motion to enlarge, motion to reconsider, and then the motion to sever. Is that correct?
Yes,
Yes,
Your
Your Honor.
Good afternoon.
Good afternoon. How are you, Mrs. Perez?
Doing well. How about yourself, Your Honor?
Doing okay, doing okay. All right. Do we have all the parties on our video conference now that we should need in order to go forward with our 1:30 hearing?
It appears so to me, Your Honor.
Okay. All right. Then I will go ahead and call this case at this particular time. It is cause number DC 17-14703, Longhorn Locker Company LLC versus Holman Court Systems Incorporated. It's set at 1:30. There are a few motions that are scheduled at this particular time that the court is going to take up. And that is a motion to enlarge the page count limitations, a motion to reconsider, as well as a motion to sever. And there have been responsive pleadings filed back and forth in response to those. So the court has its huge stack of papers here that it went through on yesterday and has it here to refer to today. So at this time, let's just get on the record everybody's names and who they represent. And then we'll take up that first motion, and that is the plaintiff's motion to enlarge the page count limitations.
Good afternoon, Your Honor. Courtney Perez for Longhorn Locker Company. I have asked Mr. Cleveland as well, counsel for Longhorn Locker Company, during most of the proceedings so far to join us. And it looks like his associate, Angelique McCall, is with us as well, all appearing on behalf of the plaintiff, Longhorn Locker Company.
All right,
Lloyd
thank
Ward.
you.
Yes, Lloyd Ward here on behalf of Holman Court Systems, Inc., defendant, Your Honor.
All right. Okay, well, I will hear from Mrs. Perez as it relates to their motion to enlarge the page count limitations.
Thank you, Your Honor. As you know, the rules that have been put in place during the COVID pandemic limit the briefings as well as the appendices that are filed to 25 pages. And you can seek leave if it's necessary to exceed that page limit. Presumably that is so that the court can efficiently dispose of things during the pandemic when it's receiving almost everything and having to deal with everything electronically. We do not take this lightly in seeking a motion for leave, but we thought it was particularly important to do so with respect to these pleadings because, as Your Honor well knows, we've had a couple of different judges in the 95th. There is an extensive record that relates to the motions, the motion for reconsideration, and I think that are inextricably intertwined with the motion to sever that Your Honor will hear today. So the most important thing, in my opinion, that required a motion for leave was for Your Honor to be able to review the transcripts of those proceedings. When we are asking you to review the record about what happened at summary judgment, I think it's particularly important that you have the opportunity to see for yourself what transpired at those hearings. And so the transcripts from the September as well as the October summary judgment hearings were attached to our motion. You will also see that we have cited to several discovery responses in our motion for reconsideration. And we thought it was important that you see those discovery responses as well. It's not appropriate to just include them in the motion, but Your Honor should have the actual evidence underlying that supports the motion. And there are also the corrected judgment that we'll be discussing today, in addition to the original judgment that was entered. Those are at issue. So we thought it was important that Your Honor have those pleadings as well as the amended pleading that we sought leave to file, because all of those issues relate to what Your Honor will be discussing and taking up today. And I thought that it was important that you have that information available at your fingertips rather than searching a very lengthy docket for the things that were cited in our motion. So we ask that you grant leave for us to be able to exceed that page limit requirement for the purposes of entertaining the motions that Your Honor will take up today.
All right, thank you. Mr. Ward, your objection, you filed an objection to the motion to enlarge the page count?
Yes, Your Honor. One, this has been an ongoing problem. As I'm sure the court's aware, if you've looked at the file, we've had no less than 4 summary judgments. We've had a motion, a plea to the jurisdiction. All of them have been over 200 pages. One of them was almost 600 pages. So, I mean, this is not the first time we've had an issue. It's been an ongoing issue. But in particular with this motion, they attach 134 pages from the transcripts. That would be inappropriate to begin with, because if you're going to quote from the transcripts, much like we did when we filed ours, you take out the particular page and you do line and page number. Had they done that, at least by our count, that would have been about 10 to 12 pages. Second problem is they attached 88 pages, which are prior pleadings in this court. This court can take judicial notice of the pleadings that's on file with it. You don't need to attach prior pleadings in this case. In addition to that, we've got 8 pages, which is simply the 2 orders, which again are on file with this court, in which this court can take judicial notice of. This is stacking up pages for a reason that there's no need to, Your Honor. I mean, the court can take judicial notice of its own file. All they need is a cite to what the pleading is, or much as we did, we simply attached the first page so that the court can find it in the court's files. We didn't need 134 pages of transcripts to read. We just don't feel that this is necessary, Your Honor.
All right, any final words, Mrs. Perez?
Yes, I will say that with respect to just particular portions of the transcripts that Your Honor may want, if you are inclined to deny our motion or modify the order in any way, we will be discussing particularly pages 69 through 85 of the summary judgment hearing. So, Your Honor, that's almost 20 pages itself, and you'll see that that's where a lot of this that we'll be talking about was discussed with respect to the TUTSA claim. But again, we'll be touching on both summary judgment hearings. I don't think it's necessarily appropriate in this circumstance to just give Your Honor 1 or 2 pages by line that may highlight what we're talking about. I think that it's important that you have the background where we say nothing was ever argued or mentioned. I think it's important that you have the entire transcript to see that for yourself. So we would ask that you entertain that, and we don't take it lightly that we move for it. Thank you for hearing me out.
All right, with respect to the plaintiff's motion to enlarge the page count limitations, I am going to make an exception to our sort of COVID requirements that it be limited to 25 pages because I am new to this particular case. And quite frankly, when I was preparing for the hearing and looking at all of the prior history, in order for me to make an informed decision, especially as important as to whether or not someone should get a new trial in this particular matter, I think it's important for me to make sure that I consume everything I can to bring me up to speed. So I am going to grant the plaintiff's motion to enlarge the page count. This is an exception, but I felt that it was necessary in light of all of the hearings that have taken place with response to this particular case. So I have signed the plaintiff's motion to enlarge the page count limitations, granting that, and this order will be on file with the court by the close of business today. So let's take up our next matter, and that is the motion to reconsider.
Yes, Your Honor, thank you. We filed a motion for reconsideration of the summary judgment that appears to potentially have been inadvertently entered on our tortious interference claim, as well as supplemented that motion with one additional ground that the summary judgment that was entered on the trade secret misappropriation claim was also erroneously entered. So I will take up the first, and I think the first thing that you will have to decide, Your Honor, is whether this motion was timely filed. As Your Honor will note, we have filed a motion for reconsideration / motion for new trial. And that rule requires that those be filed within 30 days of final judgment. And so the first question that Your Honor must decide today on both the motion for reconsideration as well as the motion to sever is whether or not the corrected judgment that was entered by Judge Lee was in fact a final order. We do not believe it was a final order, and it is because it is clear that the counterclaims, if nothing else is clear from that order, Your Honor, it is clear that the counterclaims that Holman has asserted against Longhorn will proceed to trial because they never moved for summary judgment on those claims.
Let me ask a question before we get too far down the road in terms of timing. If it is the plaintiff's position that the first order of business is to decide whether or not it's timely filed, and I know there were some corrected judgments that came after that summary judgment hearing, give me the time frame and when those came out just so that I'm able to track that.
Yes, Your Honor. So the initial order was entered on October 19th.
Okay.
And then the corrected order was entered on October 20th.
Okay.
And then our first motion for reconsideration or motion for new trial was filed on December 7th.
Okay.
So, Your Honor, it would have been past 30 days if, in fact, this order were final. And there are several reasons why the order is not final. The first is, as I said, it didn't dispose of all of the claims at issue in this case. So, and every party acknowledges that. In fact, after the first order was issued, Mr. Ward moved the court for a corrected order, just clarifying that his counterclaims would go forward. Okay, so that's the first indication that this is not a final order. The second indication that it's not a final order is the fact that Mr. Ward has moved to sever at all. If it were a final order, there would be no reason to have to move the court to sever his counterclaims. And the reason he wants you to sever them is so that he can have a final order as to Longhorn's claims so that they have a res judicata effect to his benefit in the federal court. Of course, if the order is not final, they have no res judicata effect. Hence the urgency of having his motion to sever heard before the summary judgment briefing is finished in the federal court. So that's the second indication that this order is not final. The third indication that the order is not final is the fact that, and this goes directly to the substance of our motion for reconsideration, and that is what the court did with Longhorn's tortious interference with prospective business relations claim. Just sort of by way of background, Your Honor, and I know that you have read some of those pleadings, so you know generally what this case is about. Longhorn designed custom lockers for several big players in the NCAA as well as the NFL. And those locker designs were developed, in this case, with the New Orleans Saints for almost a year before they were specifically technically drawn up and provided under confidentiality to the New Orleans Saints. One of the New Orleans Saints vendors then provided those confidential photographs, as well as the technical renderings, as well as our pricing to our direct competitor, Holman, in this case. Holman then took those technical designs to its own engineer and asked them to make a direct copy of our technical designs. And then they went, using our confidential pricing information, undercut our pricing with the New Orleans Saints and told the New Orleans Saints, we can make you the exact same design for less. And that is how they obtained the New Orleans Saints contract. And so there are two different elements of that underlying trade secret claim. But we have also stated a claim for tortious interference with prospective business relationship. And you will see that clear as day on the face of the live pleadings. Now, Mr. Ward has argued now for the first time in his amended motion to sever that our tortious interference claim was simply a misnomer, that we have just reasserted our misappropriation claim and titled it a tortious interference claim. But what Your Honor will notice from the face of the pleadings is that we have specifically laid out a separate claim. We've listed all of the elements, all of the facts that are listed in that pleading support an independently tortious conduct. And probably the most important thing you should know about this claim is that Mr. Ward never moved for summary judgment on the tortious interference claim, ever. It is not part of the pleadings. It's not part of the summary judgment briefing at all. In fact, his summary judgment was entitled a partial motion for summary judgment. So I don't think he'll be able to represent to you that he ever sought summary judgment on our tortious interference claim. And so the court then, in entering its corrected judgment, nevertheless entered a take nothing judgment against Longhorn. And that means that it didn't only enter summary judgment against us on the TUTSA claim, it also it entered summary judgment on a claim, the tortious interference claim, that was never moved upon. And that, Your Honor, is a gross error. It is contrary to well-settled Texas Supreme Court law. We have cited to multiple cases on this point, Your Honor. The first is the McDonald versus Southside Independent School District case. That's a 1993 Texas Supreme Court case. And the site is 858 Southwest 2nd, 337.
Okay.
And the Texas Supreme Court held in that case, summary judgment must be, a motion for summary judgment must expressly present grounds on which it is made. And you will see if you review their summary judgment, it was never in there whatsoever. The other case that we've cited to is the GH towing case, and it's a 2011, another Texas Supreme Court case. The site is 357 Southwest 3rd, 293. And that case held, and I'll quote, granting a summary judgment on a claim not addressed in the summary judgment motion, therefore is as a general rule, reversible error. And then the last one is McNally versus Guevara. It's a 2001 Texas Supreme Court case, 52 Southwest 3rd, 195. Quote, there can be no presumption that a motion for summary judgment addresses all of the movement's claims. So it was error for the court to enter judgment, if it intended to do so, on our tortious interference claim. That claim is still live, and that claim should be going forward.
The tortious interference claim of the plaintiff, was that included in the petition? Although I understand the defendant's position is it's a misnomer. It really goes to the misappropriation. I'm trying to find out, was it in the pleading? Were there any special exceptions to that particular cause of action if it wasn't clear? if it was a misnomer. So
It
I
was
guess
in
I'd
the
like to
pleading.
know about the special exceptions, if any.
It was in the pleading, Your Honor, and there have been no special exceptions filed either to the to the tortious interference claim or to the misappropriation of trade secrets claim, which will bring me to my second point on the motion for reconsideration, if Your Honor is ready for me to move on.
Yes.
Okay, so the second grounds for our motion for new trial and motion for reconsideration is based on the court's disposal of the misappropriation of trade secrets claim. And as I stated earlier, it has been clear since the beginning of this case, in our opinion, that our trade secrets that we claim are misappropriated really fall into two buckets or two categories. One is the design of the lockers, right? That includes the photographs, that would include the technical renderings and such, but it also includes the pricing. And Your Honor, pricing is specifically mentioned in our petition, in our live petition at paragraph 7, as well as paragraph 10. But not only that, as Your Honor will note from the briefing that we have done, it is specifically included among our interrogatory responses where we delineate the trade secrets that we contend are at issue in this case, as well as significant document discovery and depositions, inquiring specifically as to pricing. And so you can imagine our surprise when we get to the summary judgment hearing and Mr. Ward argues that, well, I don't know why we're talking about pricing because it's not in the pleading. Now, we included the transcript of that hearing, Your Honor, and again, that discussion appears on pages 69 through 85 of the October 12th summary judgment hearing. And in that, in response to Mr. Ward saying, bringing this up at the hearing, Judge Lee inquires as to where pricing has come up in the case. And he clearly concludes during that hearing that we did not adequately plead pricing as one of the trade secrets that we allege to have been stolen by Holman in this case. So we are not introducing any new evidence on that point. We are merely directing you to that. And then the court enters summary judgment against us on our misappropriation of trade secrets claim. It's clear from the transcript that the reason that the court did that is because the court did not believe we had adequately pled a misappropriation of trade secrets claim with respect to the pricing. The problem with that, Your Honor, is that the Texas Supreme Court holds black letter law again. It is an error for the court to enter summary judgment on a claim because it was improperly pled. So we have cited to some other, or inadequately pled, I should say. We have cited to Texas Supreme Court cases on that point as well. I will give Your Honor those cites. One moment. The first case is the Herring case, and that's a 1974 Texas Supreme Court case. The site is 513 Southwest 2nd at page 6. And it holds, quote, the protective features of special exception procedure should not be circumvented by a motion for summary judgment. Another case, a 2000 case, Texas Supreme Court case, the Horizon case. It's 34 Southwest 3rd, 887. Quote, an opposing party should use special exceptions to identify defects in a pleading so that they may be cured, if possible, by amendment. Holman never filed any special exceptions whatsoever to our TUTSA claim. So we never had the opportunity to replead. And then to compound the error in this case, Your Honor, our motion for leave to amend the pleading, which is what should have happened, special exceptions, opportunity to amend, then entertain the summary judgment. Our motion to amend the pleadings, which the court took up at the same time as the summary judgment, you'll notice from the transcript, that was denied. So not only were special exceptions, we never had an opportunity to be put on notice about any pleading defect, but summary judgment was entered. We never had the opportunity to replead, and that is contrary to Texas, well-settled Texas law. I imagine that Mr. Ward's response will be, well, since the court entered summary judgment on the TUTSA claim, then it necessarily disposed of the tortious interference claim. And that's not the case, because we don't have to prove the underlying tort in order to succeed on a tortious interference claim. Again, you only have to assert facts that would, if proved, constitute an independent tort. And so if he took issue with that, right, what's the basis for our tortious interference claim apart from misappropriation of trade secrets? He never specially accepted to that either. And so it was error for this court to grant summary judgment on not only the tortious interference claim, but also the misappropriation of trade secrets claim. If in fact it did so because of a pleading defect, that is improper. Under well-settled Texas Supreme Court law, the court still has plenary power to correct these errors. And Your Honor, the final thing that I will say is it is not the best use of the court's resources to move forward with a trial on these counterclaims when these facts and the evidence will be intertwined. And it's not efficient, whether Your Honor corrects this judgment now or whether it's corrected by the Court of Appeals, to then have to come back and retry this case all over again, particularly when the court's resources are strained. So I would urge the court, while it has plenary power to do so, to correct anything and sort of right this ship so that we can be headed to trial in the correct posture in this case, that Your Honor would vacate the judgment for the reasons that we have stated here, correct the summary judgment record, and that being denying Ward's summary judgment, Holman's summary judgment motion on both the tortious interference as well as the TUTSA claim, make clear that these claims are going forward, and set the case for trial.
All right, Mr. Ward.
First, Your Honor, I think the court, just a brief background, and the court may be familiar with this. What they're trying to have this court overrule, void, throw out, reverse is in fact a set of motions in which, if you look at paragraph 5 of our response, there was a motion for leave to file amended petition, objection and motion to strike defendant's supplemental summary judgment evidence in support of its motion for traditional and no evidence summary judgment. Plaintiff counter defendant's amended no evidence motion for summary judgment, traditional motion for summary judgment in brief in support of, plaintiff's motion to strike defendant's summary judgment evidence, and plaintiff's motion to strike defendant's summary judgment evidence in support of its motion for traditional and no evidence summary judgment. That was just the plaintiff's motions. Defendants simply had a motion for traditional and no evidence summary judgment. These hearings took place over a 2-day time span. We heard part of it one day, the court recessed, asked for some briefing. We came back, almost 3 hours of argument. This is not something which was breezed through. This is something, not only was it briefed, it was briefed over and above the point of being able to claim that there was anything that was left out, deficient, etc. So please understand, they're asking you to throw out something in which they alone had 5 motions set that day. We had 1 motion, 2 days, almost 3 hours of time. So this is something that was indeed fully argued and fully considered by the prior judge. Okay. Now I'm going to do this in a slightly different fashion, because the problem in regard to the untimeliness of the 329B, you have to understand there's a distinction. The court has plenary jurisdiction, and there's no question about that. The question is the procedural posture in which they're able to present their motion. 329B clearly states you only have 30 days to file a motion for a new trial. But B says upon leave of court, if you're under 30 days, then at that point in time, you can still have the court hear it because it has plenary jurisdiction. So in other words, Your Honor, they missed the 30-day time span. They could have presented this, because there is no question it is interlocutory. All the counterclaims are still pending, but you can't do it with a motion for new trial in and of itself. You have to seek leave of the court for purposes of presenting the motion for new trial. That's what the order clearly states. And, it's As a matter of fact, and we cite the court on page 9 to the Rentenna, the Wagner, and the Hyde case, and those cases all stand for interlocutory, and that is a simple proposition, and that is that while a court retains plenary jurisdiction, the 30-day time period still stands. It's how you address it. They can't simply file a motion for a new trial and say, we, as a matter of right, have the right to go forward with the motion for a new trial. In fact, they have to seek leave of court, at which point in time, then they can file their motion for new trial. So the first problem we have is that the two motions that they file are the motion and amended motion, procedurally speaking, are not properly before the court today. That's the first issue that we have. Next thing I would like to go forward to is when we say misnomer, Your Honor, that's really not claiming a misnomer as in that it's not properly pled. What we're saying, if you will, and as a matter of fact, one of the things that we had attached was transcripts where we pulled out from the trial because our motion for summary judgment was making a finding that there was no violation of TUTSA. The reason we did that was because there was actually three things that were filed. There was TUST on its face, tortious interference, which was based entirely by their own pleadings on our violation, on their allegations that we violated the TUST and therefore interfered with their contract solely because of the TUTSA, and then exemplary damages. So we addressed that in the aspect that if there's no TUTSA, there are no claims. And as a matter of fact, we have attached beginning at page 25 on the court's transcripts. And the court said, and now tell me how you've established grounds for summary judgment on the tortious interference. Your Honor, here's the thing, court, because to be blunt, yes, sir, court, this sounds a lot like tortious interference and misappropriation of trade secrets. Mr. Ward, I don't disagree with you. And this is kind of our theory, Your Honor. If you take the trade secret issue out, and that's what they had pled as being tortious interference, is the fact that they took that design and used it for their design. So as a practical matter, if there is no trade secret in their pleadings, that's their tortious interference claim. And I'm not disagreeing with the court that it should just be a quote unquote tortious interference if they want to go that way with it. But the way they have pled it is based all under the Texas Uniform Trade Secrets Act. So if there's no violation in the there's no violation in that under
Mr. Ward, your internet, I'm not sure if it's lagging, but it is buffering somewhat. Mrs. Rouse, were you able to hear on your end?
Most of it. I was about to interrupt myself. But I think I got it.
Okay, go ahead and proceed, Mr. Ward.
Sure. So as a practical matter, if there is no trade secret under their pleadings, that's their tortious interference claim. And I'm not disagreeing with the court that it should be just a quote unquote tortious interference claim if they wanted to go that way. But the way they pled it is they based all of it under the Texas Uniform Trade Secrets Act. And so if there is no violation in that under their claim for tortious interference, it just kind of wipes out their claim. Respond to that, Mr. Cleveland. This is Mr. Cleveland. To have tortious interference claim, you have to have an independent tortious wrong. I believe that element under 3 on our tortious interference claim, and what we've alleged is a misappropriation, is that the independent tort or wrong conduct of the element 3. If you then go over to page 29, and this is Mr. Cleveland, let me say this, Your Honor, if you're going to grant summary judgment on the TUTSA, it might as well be a grant of tortious interference too, because the Texas Secret Act claim is the wrongful conduct that supports the element for the tortious interference. Oh, so you are agreeing with Mr. Ward earlier. Mr. Cleveland, yes, I am. Mr. Cleveland, I'm agreeing with him. The court, all right, Mr. Cleveland, if Your Honor wants to do that, then we're going to have a record that proves that we have raised a genuine issue on whether or not there was a trade secret and whether or not that was misappropriated. In fact, our argument was you wipe out the TUTSA, that is the essential element of their, and when I say their claim, because the TSTA is the claim. The TSTA is the tortious interference. The TUTSA is the exemplary damages. The TUTSA is the act itself. Mr. Cleveland agreed with the court and said, if you wipe out the TUTSA, that wipes out our tortious interference claim. On the record, Mr. Cleveland agreed with that. And in fact, on the September 10th, 2020, he stated, and this is at page 2, and this is their letter brief that the court asked to send out. Longhorn's claims are limited to Holman's misappropriation of Longhorn's trade secret designs and confidential pricing that directly caused New Orleans Saints to abort its business transaction with Longhorn in favor of Holman. Your Honor, that's what's been pled all along. That's what the summary judgment was. And if you actually take a look at the two orders, that is specifically addressed, and not in the original and the amended order. Both of those, the court specifically found that all of plaintiff's claims are denied. That didn't change from the original to the amended. And what we have done, Your Honor, and we have cited court to, give me just a moment.
Mr. Ward, just a quick question while you are looking for that particular reference for the court. I just want to make sure that I understand basically the posture of the defendant. As I understood the plaintiff, there's a claim, or they believe that they alleged a claim for tortious interference with business relationships. And you are saying that particular claim cannot stand independent if there is no trade secret information found to be?
Yes, Your Honor. And if you look at their fourth amended petition, that is literally what it states. If you take a look at count 2 in their tortious interference, it says that the tortious interference is our misappropriation of their trade secret causing the New Orleans Saints to terminate their contract, which is exactly what Mr. Cleveland said.
And if the trade secret, though, is purported to be pricing, and I need to look back at my notes, the design of the locker.
Well, can I get to that in one moment, Your Honor?
Okay.
I promise I'll address that. That's
No problem.
an issue. And if you take a look at page 11, we cite the case to the Nell versus Texas Supreme Court 2013.
Can you say the name of that? Can you say the name again? You cut out.
Sure. It's page 11. It's Nall, N-A-L-L versus Plunkett. It's at page 11 of our response to their motion for new trial. In the Supreme Court, that was a personal injury case in which there were various causes of action, basically all on negligence. The court came in, ruled that there was no negligence, and based upon that, ruled against them on several causes of action. On appeal, they claim, well, wait a minute, you didn't specifically name those causes of action. And what the Supreme Court said is, when the defendant has a duty to plaintiff in a factual scenario, the defendant, short answer, Texas does not recognize a social host and does not have a say of duty. The Court of Appeals, let me get down to it, the Supreme Court held, okay, it's paraphrasing, but the Supreme Court said that because the cause of action for negligence was found against them, that those claims all went out the door. So in other words, because they pled there was no negligence, that obviated and deleted all of those claims. And that's Texas Supreme Court 2013, Your Honor. And it was specifically addressed in our motion for summary judgment. And I give a cite to the page numbers. I'll have to get back to you on that, but we spent about 6 pages addressing the TUTSA claim and that there was no violation of TUTSA, therefore plaintiff had no cause of action. The reason we entitled it a partial summary judgment, Your Honor, is because we didn't file anything in regard to our affirmative causes of action. So the granting of our summary judgment is only partial, not because it delineates and deletes their claims and rules against them, but because it leaves our claims all intact, which is exactly what the court did. And if the court looks at page 2 of both the order and the amended order, it addresses these issues. Now, let me get to this pricing issue. Your
Yes.
Honor, that one is one in which there was a substantial amount. They filed a motion for purposes of amending the pleading. We filed a response. They filed a response, and the court specifically addresses that on page 2 of the order and the amended order. Because here's the problem. They had a laundry list of things that they claimed were proprietary. Pricing was one of the laundry list of things they claimed was proprietary. And what the court pointed out was that in paragraphs 19 and 20 of their amended petition, their third amended and fourth amended petition, they say specifically these are the trade secrets which Holman misappropriated. And they use the word specifically. They also did that in regard to their disclosure responses. And it lists A through J. And it's in the transcripts, the court reads off A through J. Pricing is not there. So understand it's a red herring and it's also a misdirection. They say, oh, we talked about pricing throughout this. Pricing was one of a laundry list. Pricing, design, cost, vendors, etc. It was one of a laundry list of things that they claimed were proprietary. We never got to the issue of whether or not we violated the pricing or whether pricing was TUTSA or anything else, because they say in their third and fourth amended petition and disclosure, specifically, these are the items which Holman misappropriated, and it lists them. Now, Mr. Cleveland's response on that, as the court can see from the transcript, was, well, but Your Honor, even though we didn't say specifically, they should have had notice of it. And the court came in, and again, in number 2 and number 3 states, they say specific items were misappropriated. Pricing is not what they said was specifically misappropriated. And it's not an issue of whether they claimed it was proprietary. It was never litigated because there was never an allegation that we misappropriated it. And Your Honor, again, it's in the court transcript. It's in the order and the amended order at page 2, specifically on both of those. So no, to say that pricing is an issue is a red herring, because did they put it in their laundry list? Absolutely. Did they claim we misappropriated? No, they didn't. And we didn't need to special accept because it isn't something they claimed we misappropriated. And mind you, if you look, they use the word specifically. That's their language, not our language. And that's what the court held them on. That is, you specifically said these were what was misappropriated. Can you direct me to where you say that this was something they misappropriated? And while Mr. Cleveland went back and say, look, we mentioned it, the court went back, looked, and specifically found you never claimed it was misappropriated in your pleadings. So to get into the pricing at this point, after not only it was briefed, fully briefed, and argued for a fairly substantial amount of the second hearing, is a red herring. So in order, is adequately pled, pleading defect. Your Honor, it's not an adequate pleadings or pleading defect. When you say specifically, this is what you stole, you can't come back and then say, oh, well, that's not what we really meant. It's not a pleading defect. It's simply going on the face of the pleadings in the four corners of the document. Now, for them to now say, oh, and you shouldn't sever because it's intertwined. Again, Your Honor, that's kind of interesting, because if you take a look, what they actually said in their pleading and in several of the things that they filed is this. Their claim is solely in regard to the contract in the New Orleans Saints. We haven't pled a cause of action against the New Orleans Saints. In the same letter brief, which is again was provided to the court, if the court will give me one moment to pull it up. Here we go. And again, I'm going to read directly from Mr. Cleveland. This way, there's no question about what was or was not the position. Again, Longhorn's claims are limited to Holman's misappropriation of Longhorn's trade secret designs and confidential pricing, and directly caused the New Orleans Saints to abort the business transaction with Longhorn in favor of Holman. That's it. He then goes on the next hand. On the other hand, Holman's counterclaims relate to all of Longhorn's communications with its customers and potential clients. Holman claims Longhorn made false statements to its customers and potential customers that it had certain proprietary rights to certain designs and function aspects of custom lockers when it did not. That's what they said to the court. They now have decided, I guess they've changed their mind. But in their letter brief, which they presented to the court, they admitted all of their claims revolve around the New Orleans Saints contract. None of our counterclaims touch on the New Orleans Saints contract. We haven't mentioned it in ours, except in regard to defense. Our claims have to do with a number of documents, letters, threats, things that were sent out to potential clients, not New Orleans. These were all things that occurred after the New Orleans Saints, Your Honor. So, I mean, they had admitted, at least up to this point, that these claims are completely different. They have nothing to do with one another. So at that, Your Honor, I'll pass it back to the move on.
All right, let me just ask one quick question, Mr. Warden. I don't want to spend a lot of time relitigating what you all have already had long hearings about, but this pricing issue, is that typically not confidential information? I mean, if you have a product that you're building and you have a competitor out there, typically they want to beat your pricing. Is that not confidential information that would only be available to the plaintiff?
The answer to the question is not necessarily, Your Honor, because understand that this is a business in which there are not that many competitors. So, and by the way, just as a side note, a lot of the testimony was that everybody pretty knows what everybody else's estimate's going to be, because you can't be that far off. Everybody's building essentially, basically a box. It's a locker. Everybody essentially knows what it is. But understand, the problem wasn't whether or not it's confidential. The problem was that they never pled that we misappropriated it. When you use specifically in list H through J, the court said you're stuck with what you pled because you didn't say they stole it.
All right, thank you. I will hear from Mrs. Perez, the response to defendant's argument.
Thank you, Your Honor. So far, what I heard today about Mr. Ward is to reiterate the fact that he believes there was a pleading deficiency. And he thinks, Your Honor, that the court was correct in entering summary judgment where there was a pleading deficiency. And the reason that we have moved for a new trial is because that is not the law. So we dispute that we inadequately pled the pricing issue, but that's fine. Let's set that to the side. Let's assume that everything Mr. Ward just said is true. And we were deficient in our pleadings and we didn't specifically list it. Let's assume that's true. What does the law say is then required? The law says if there is a pleading deficiency, and all of the Supreme Court cases that we've cited, Your Honor, to today, says if there is a pleading deficiency, the proper procedure is to specially accept to that. And then the court should offer the plaintiff and allow the plaintiff an opportunity to replead. You may not dispose of a claim for failure to state a claim, which is basically a pleading deficiency, on summary judgment if the plaintiff has not had an opportunity to amend, because that is the law. And the court clearly did not follow the Texas Supreme Court law laid out on this point. The judgment is an error and it must be set aside. That means the judgment on the Tutsa claim has got to be vacated. The Tutsa claim is still alive. And if that is the only underlying tort that supports the tortious interference claim, then we don't have a deficiency on the third element of the tortious interference claim, because the Tutsa claim is then going to go forward. And so the remaining question is, was there any other basis whatsoever to enter summary judgment on the tortious interference claim? The answer is no, because one, they never moved upon it. And again, the Texas Supreme Court says you cannot, as a matter of law, you cannot enter summary judgment on a claim that was never moved upon. And then two, if it was moved upon, was there any other basis other than saying, well, your Tutsa claim is thrown out and therefore your tortious interference claim necessarily dies? Was there any other grounds raised? And the answer is no. Our tortious interference claim, the elements of that were never at issue. They were never brought before the court. There was never any allegation that there was no evidence to support each and every element of our tortious interference claim sufficient to survive and go forward on a motion for summary judgment. So we know that's the only basis that the court would have granted summary judgment on the tortious interference claim. The last thing I will say is with respect to whether the tortious interference claim can go forward even if our underlying misappropriation of trade secrets claim does not? And the answer is yes. The answer is it still can go forward because all the courts require is that you sufficiently allege facts that, if proven, would constitute an independent tort. If we prove the facts that we allege, that they stole and misappropriated any number of those trade secrets, then that doesn't have to be proved. We just have to sufficiently show that there is conduct that would give rise to an independent tort. And I want to direct your honor to one case on this very point that is very similar to the facts that we have in this case. And it's called Astoria Industries of Iowa versus SNF. And I'll give you the cite to that. It's a case out of the Court of Appeals in Fort Worth, and it's a 2007 case. The site is 223 Southwest 3rd, 616. And in that case, a manufacturer of some commercial utility toppers for commercial utility vehicles brought a claim similar to this case for misappropriation of trade secrets, tortious interference, business disparagement, and the like. And in that case, there was a question about whether or not there were facts supporting an independent tort that would underlie the tortious interference claim. And the court held in that case, for purpose of proving an independently tortious or wrongful act by the defendant that prevented the plaintiff's contractual relationship with the third party from occurring, as an element of claim for tortious interference with prospective business relations. Independently tortious does not mean that the plaintiff must be able to prove an independent tort. Rather, it means only that the plaintiff must prove that the defendant's conduct would be actionable under some recognized tort. There's no dispute that misappropriation of trade secrets is a recognized tort, which brings me to the case that Mr. Ward pointed the court to, which was the Null case, the Texas Supreme Court that he cited to. The most important thing to note about that case, Your Honor, is that the reason that the tortious interference claim fell apart was because the quote unquote underlying tort that they were, the independent tort that they were relying on to support that claim was not an existing cause of action. It doesn't exist because Texas does not recognize social host liability, which was the underlying tortious action that they were claiming happened. And so if it's a claim that the law does not recognize, it can't, as a matter of law, no matter what you allege, support any showing of independently tortious conduct. That's not the case here. Clearly, misappropriation of trade secrets under the Texas Uniform Trade Secret Act is a recognized cause of action under Texas law. It exists, and all we had to do is plead it. And I will leave you with this, Your Honor, with respect to pleadings on both claims. Pleadings are to be liberally construed in favor of the pleader when the complaining party has not filed special exceptions to the pleadings. And I'll give you the case quote to that as well. All pleadings must do is give fair notice of the claim or defense asserted in order to provide the opposing party with enough information to be able to enable them to prepare a defense. And causes of action may be reasonably inferred from the facts pled. We don't have to have any magic words. We don't have to specifically even prove each and every claim underlying independent tort in order to succeed on a tortious interference claim. If that were the case, Your Honor, you could only prove tortious interference to a jury if you also prove the underlying tort, and that's not the case. Tortious interference with a prospective contract is a standalone claim. It's not a claim that may only be pled or recovered on in addition to something else. It's not an additional claim. It is a standalone claim. So the case that I was just quoting from is Bank One versus Stewart. And this is a 14th District Court of Appeals case. And the site to that case is 967 Southwest 2nd, 419. And all that stands for is just the liberal pleading requirements that we would remind Your Honor are at play here.
All right.
Your Honor, may I do one brief readdress on this?
Yes.
With me. One, I find it It's peculiar that they now take a stand, which is 180 degrees from the stand they took on the record with the prior judge. Literally 180 degrees. This is the exact opposite of what they told the prior sitting judge. In the prior sitting judge, they admitted, yeah, you rule under TUTSA, it wipes all our claims out. We agree with that. Now they're taking a position, oh, well, that's not exactly true. Your Honor, their argument now is 180 degrees. And I've simply asked the court to look at page 2 of the order and the amended order. It addresses this. And there was argument ad nauseum on this because, Your Honor, they use the word specifically, this is what you misappropriated. When they say the fair notice and in their discovery, and I'm going to quote, when they identify, it includes bidding, price, features, etc. That's where price is mentioned, including bidding, price, features, etc. That's where they're saying, oh, well, you should have had notice that we included price, because in their note where they have their running list of things they think are proprietary, bidding, price, features, etc. And then they go on, and Your Honor, I would encourage the court to look at paragraphs number 19 and 20 of their petition, because they literally use the word specifically, these items are the items which were misappropriated by Holman. And that's what's addressed in page 2 of the court's order and amended order, both of them. So now for them to come back and say, oh, you should have specially accepted. Your Honor, you don't specially accept something when it's not in the pleadings. When they say specifically, this is what you did, you don't specifically accept the rest of the pleadings. We didn't have any notice of it. It's addressed, Your Honor, ad nauseum in the briefing, but just take a look at page 2 of the order and the amended order. That's all.
All right, thank you. So
Wait,
go ahead.
And that is, I'm not sure I understand, because they said the case we cite, the court found that because there was no existing cause of action for this particular item, therefore it obviated the rest of the claims. Your Honor, that was a motion for summary judgment. That wasn't a trial. That was a motion for summary judgment, and the court found this doesn't exist. Therefore, we're granting judgment on these claims because the basis of those claims don't exist in Texas. Your Honor, go back and just read count of their claim, because they say, and again, this is their wording, they say that the misappropriation of Longhorn's trade secrets resulted in the wrongful termination of the New Orleans contract. And Your Honor, and it's what they put in their briefing, Your Honor. Now they're taking a completely different view. I mean, from what they argued to the court, from what they presented in their letter briefing, they now want to take a 180-degree turn from that. They're saying, oh, well, I guess that argument didn't work. We're going to take a different position. I'm just saying.
Well, let me say this. The court believes it has a good handle on this particular argument, and the court is well aware of what it takes in order to get a new trial and what the rules require. So the court will take that into consideration. With respect to the motion to reconsider, the court does have a copy of the plaintiff's supplemental motion. Does the defendant also have a competing order on file?
Yes, Your Honor, and we can resubmit it. I've already instructed them after the hearing today to resubmit it to you, so it'll be there with you.
Okay.
I think it was also included, we sent you a download in regard to our briefing. And
Okay.
It's in that download, though. I'll have them refile it today.
Okay, I wanted to make sure that I have the appropriate order for that particular cause. Mrs. Perez, before we move on to the motion to sever, which we kind of covered a little bit, is there something, some final words, since you were the movement on this, that you want the court to be aware of?
Yes, Your Honor. Just one final response to Mr. Ward's last point regarding a failure of notice. And again, I will just point out that he has never argued that he is prejudiced or didn't have notice in order to be able to defend this claim on the pricing. And just to point out, I know he directed the court to our disclosure, so I want to direct the court to our interrogatory responses that you will see in the supplemental motion for reconsideration, where it asks us to please identify each trade secret as defined in TUTSA that you claim Holman misappropriated. And within that interrogatory response, Your Honor, we talk extensively here about pricing, as well as all of the measures that we take to make sure that we can protect the pricing as it is one of our trade secrets. And it specifically mentions the word pricing. Longhorn maintains the secrecy of its pricing information by limiting the number of people with knowledge of the pricing structure to a select group of individuals. Longhorn confidentially disclosed this information, including its confidential designs and pricing. It just goes on and on about that. So for them to argue now that they had no notice that pricing was at issue in this case is a little disingenuous, Your Honor. So that's the last sort of factual point in response to what Mr. Ward just argued. And the rest of it, again, goes back to the pleadings. So I will not revisit that.
All right, let's take up the motion to sever at this time. I know we mentioned that somewhat and whether or not that should be granted or should be denied, but I'll hear from the movement with respect to their motion to sever.
Certainly. Your Honor, at least as of today's date, all of plaintiff's claims have been disposed of pursuant to the order and the amended order. And pursuant to the amended order, the only thing which is left pending as we sit here today is the counterclaims. The claims of plaintiff, as I read to you from their briefing submitted to the court, are limited solely in regard to the misappropriation of trade secrets, and which led to the New Orleans Saints aborting its business transaction with the Longhorns in favor of Holman. That's literally their wording, Your Honor. That is the sole cause of theirs. Again, their wording is that Holman's counterclaim relates to all of Longhorn's communications with its customers and potential customers. That doesn't include the New Orleans Saints, Your Honor. Nothing in our pleading raises a cause of action in regard to the New Orleans Saints or the New Orleans Saints contract. All of our claims have to do with a laundry list of universities and institutions. Not included in that laundry list of institutions and universities is the New Orleans Saints. To say that the facts are interwoven is completely, well, and again, it's in opposition of what their prior position was. But the simple fact of the matter is, and just so the court understands, they began sending out a number of these letters that said, we're sending you this and everything contained in it is confidential and proprietary. And if you disclose any of it, we're going to sue you. And if you read it, and it's in the deposition actually of Mr. Allen, he couldn't actually tell you what that proprietary or secret information was. In addition to that, it was being sent out by Longhorn when in fact the proprietary information was owned by the Allens, who quote unquote developed it in a company called AIM, who is not a party. That is a Sam Allen owned company. And in his deposition, he stated that that they came up with the ideas, AIM developed it, AIM produced it, and that Longhorn is just a sales entity. So the simple fact of the matter is our claims revolve around these ongoing sets of letters and essentially threats that are being sent to universities. And again, they're listed in our petition. New Orleans Saints isn't there, that are threatening people with litigation in regard to things they are claiming that are trade secrets, which simply aren't trade secrets, and which, quite frankly, Longhorn doesn't own. That's our claim and cause of action. There is nothing intertwined, overlapping. As a matter of fact, the New Orleans Saints in regard to this will never even come up in our cause of action.
All right, Mrs. Perez.
Yes, Your Honor. Two things on the amended motion to sever. First, I will note that the court entertained these arguments. Judge Lee entertained these arguments on the motion to sever originally and denied that motion with leave or without prejudice to Mr. Ward refiling it if there were some additional fact. I will point out that the only additional fact that Mr. Ward has pointed out is the fact that summary judgment proceedings are now underway in the federal court. And the reason that he needs you to say he needs you to sever it is so he can get a final judgment so that he can, in his summary judgment pleadings that are now coming due, argue that there is a res judicata effect of the court's ruling. He cannot do so in good faith now without a severance because he knows that the order that was entered is not final. So that's one thing. The only fact that has changed is that he has a summary judgment pleading due. And so now he would like the court to rehear the same arguments that were previously denied. Now, as to those arguments and whether the facts are interwoven, Holman contends that its claims can go forward and they have nothing to do with our claims. And therefore, they can be severed and there can be just a new trial and there's no overlap. The problem with that, and he says, well, because we're not going to mention the word New Orleans Saints. The problem with that, Your Honor, is that in order for him to prove his claims, he will have to establish that what Longhorn said was false. That what Longhorn said about its confidential and proprietary information was false. That Longhorn, in fact, didn't have this confidential and proprietary information that it warned people about, and that the allegations that Longhorn put in these various letters cannot be supported. And so in order for us to defend against that, the same evidence that we would put on with respect to our misappropriation of trade secrets claim would then necessarily have to be put on in his case. That is to establish that we in fact had trade secrets, confidential and proprietary information, that we took efforts to protect that from people and entities like Holman, and that Holman unlawfully and wrongfully obtained our confidential and proprietary information, that it used it in one instance and we were on notice that it was attempting to use that with respect to other customers. And so to protect our interests while litigation was pending, I might add, we sent out these notices. And so the same facts, the same evidence, the same witnesses will be at play in defense to their counterclaims. And that's why we have said in our papers that our misappropriation of trade secret claim is inextricably intertwined with their tortious interference claim and their claim that we have disparaged them by saying various things. So not only are the claims themselves are not intertwined. In other words, a jury could find on their claims without rendering any judgment whatsoever on our claims. But the facts, the evidence that will be presented, the witnesses that will be relied upon are all the same. And so we don't believe that severance is proper at all where the claims are interwoven, and we have cited the law on that point in our papers. The other thing that I will mention, and he mentioned this in briefing, he talked about an entity called AIM and said that, well, Longhorn shouldn't be at issue with respect to our counterclaims because the evidence is going to show that Longhorn's confidential information actually belongs to another entity called AIM. And what I will just say, Your Honor, for purposes of this brief hearing today, is that AIM is an affiliate of Longhorn. Okay, so Longhorn is the sales arm of another entity called AIM. They are related. They have different functions, but they are related entities. And you will see overlap between duties and principles and the like with respect to that. And of course, what he has done today is raised fact issues that would have precluded summary judgment on his claim, which is why presumably he never moved for it to begin with on his claims. So we believe that this case should not be severed because one, it is clear the judgment was not final, which is why he's trying to sever it. Two, there's no basis to sever where the facts are interwoven. And then three, the court will necessarily have to decide what to do with our claims, certainly before severing the case, because if any of our claims go forward as we have argued today, certainly severance in that instance would be inappropriate. So we would argue there have been no new facts raised to support severance other than what he has raised, and that is for his own expediency, which is we really just want a res judicata effect on this so I can go ahead and get my attorney's fees and then I can try to prevail in the federal court as well. We urge Your Honor to take that into consideration. That is not a proper ground to sever a case. And we ask that the amended motion to sever be denied for those reasons.
All right, thank you. Mr. Ward, I'm going to give you final words on the motion to sever.
Sure. I find it entertaining, Your Honor, because they say the only reason we don't want it is because it'll become res judicata in the federal court. Your Honor, the problem is they lost. As we sit here today, they have lost on these claims, and they have admitted in federal court, and we copied it into the pleadings, that, well, it may be, it's interlocutory in state court, so we're entitled to relitigate the claims we lost in state court in federal court. You're now saying we want it for res judicata. Yeah, absolutely, Your Honor, because they want to relitigate claims they've already lost in state court. Now, the court left it open for reconsideration, and I will tell you as a practical matter, had Longhorn not filed the motion, the pleadings they filed in federal court and taken a position that there's no res judicata, they can relitigate them, there wouldn't be a need to sever this because those claims are over and dead. They're not going to be able to present evidence on them at trial, etc. But it does raise an issue because what it does is it gives Longhorn the opportunity to relitigate claims they've already lost in state court and federal court. So yeah, that is a significant difference. And it's just a little entertaining that they take the stand that, well, we just want to be res judicata. No, they want to be able to relitigate, Your Honor. So of course we want res judicata. We don't want to litigate this. This case is over 3 years old. We don't want to relitigate in federal court a case that it took us 3 years to get lined out in state court and get judgments in. I know that may sound a little odd, but after spending 3 years, we don't want to redo it. So yeah, no, that is a significant change and a significant difference. In regard to the facts, Your Honor, they're presupposing that they're going to get a motion for new trial, I suppose, because they say they're going to put on evidence that they own the trade secrets. Your Honor, that's not the issue. The issue is they were sending threatening letters out, and the testimony is they can't even tell you what the trade secrets was. Sam Allen at his own deposition couldn't tell us what the trade secrets were or what the proprietary information was. Looking at his own letter, he couldn't tell you. And again, it's a little disingenuous because they're saying, well, AIM is a related entity and you'll find out overlapping, et cetera, et cetera. I guess they're taking a position that if we get a judgment against Longhorn, we can execute on that judgment against AIM. Is that what the proposition we're hearing is, Your Honor? Because I'll make you a promise. We take a judgment against Longhorn, and they're going to take the position we can't execute against AIM and we can't execute against the Allens because they're not parties to this case. Saying that they're related entities, unless they want to admit that there's been commingling and that we can execute against all of those entities, is very much misleading. That's all, Your Honor.
All right, thank you. Mr. Ward, I know that when this hearing was set last week, we were trying to make sure that we secured a hearing date for you all before your briefing was due in the federal court.
Yes.
What is that timeline again, if you could apprise the court? Because I want to be able to set a realistic time frame to get orders to you all with respect to the hearing before me today.
Feel free to correct me, but my understanding is we were told by we're not handling the federal claim, and I have been told that the 15th is the date that they need to be able to file a response on.
Okay. All right. That gives me some time. Mrs. Perez, did you want to add anything?
Yes, Your Honor, just one. We do have an objection for the record to their proposed order granting the amended motion to sever. That order lays out specific findings of fact with respect to the summary judgment motions that were never made or never entered by the court. And so we would object to that to the extent that there is some entry of some findings that the court never made, particularly number 3, the title of Longhorn's count 2, tortious interference with prospective business relations, is a misnomer, as it is merely a restated claim for misappropriation of trade secrets. And then it goes through 4 through 7, particularly lay out specific factual findings with respect to the motion for summary judgment that the court never found, and they've never filed any sort of motion or request for entry of findings of fact and conclusions of law with respect to the summary judgment motion. So the order that they have submitted to you is improper and goes several steps beyond what we believe is appropriate. And the substance is what they've asked for in their motion to sever, but what they've laid out goes a step beyond that in the orders.
All right.
If
With
you are
respect,
me just Xing that out and initialing it, I'm sure is going to be more than adequate.
all right. Well, I definitely can interlineate an order that has been presented to the court. So I know how to do that. With respect to 2 orders that this court owes the parties, that is on the motion to reconsider and the motion to sever. The court, I am going to have that order to you all by the morning, hopefully before I sit down to start my docket tomorrow. The way that you can anticipate receiving that particular order is my court coordinator will basically send you a scanned copy of the order that I do sign. The only order that has been signed with respect to the motions that have been before me today is on the motion to enlarge. So I'm going to take that over to the clerk's office when I finish, and they'll go ahead and get that uploaded. So I just wanted to make sure that we all understand what you are waiting on from the court and when it should arrive to you. Are there any other questions for me?
None, Your Honor.
No, Your Honor.
All right, then that concludes our hearing. Thank you all very much.
Thank
Are
you
we-
for your time, Your Honor.
Take care. Bye-bye.